Good afternoon, everyone. Thank you for joining us here today for our IP webinar series with our friend, subject matter expert, and huge supporter to Ignite You, Daniel T. Kane. Over the next 3 weeks, Dan Kane will be talking best practices and strategies around intellectual property. This is a 3-part webinar series, all totally free for you guys to take advantage of. And if you guys aren't able to fully watch it here today, we also will be recording it and reposting it on social media to host on our YouTube channel as well. So we appreciate you guys being here today. Some housekeeping items, and if Dan, correct me if I'm wrong, but we want this to be a very engaging, interactive conversation rather than a presentation. So if you guys do have any questions, please put them in the chat at the bottom right of your screen. You guys should see a chat feature on there in WebEx. Just comment your question that you have in real time, and I will get Dan's attention and ask you that question, ask him that question on your behalf. But if you are comfortable being promoted to audio and want to ask him that via audio yourself, maybe in parentheses of your question, just put audio, and I will promote you and unmute you from there. I will go over some housekeeping items at the end, kind of going over part 2 for next week and some stuff that we have going on at Ignite You. But Dan, thank you so much for being here. We really appreciate your support to Ignite You, our community, and our ecosystem of entrepreneurs. So the floor is yours, and I'll stop talking now.
Well, Sam, thank you for the introduction as always. It is always a pleasure to talk with the folks at Ignite You and also to help with all of the stakeholders that use your resources to try and build up New York State, but also across the Northeast and across the country. So thank you again for everything Ignite You is doing, and thank you for the invitation to do this webinar. Thank you to all of you out there as well who are attending. As Sam said, if you have any questions during the entire presentation, please feel free to ask them in the chat or to flag it for Sam, and he will try and give you the floor to ask me a question. We have a lot of content to cover today. I'm going to go through some of the general IP content and then specifically through a lot of the patent content, because as we know, today is about patents. The other 2 pieces of the webinar series are going to be about trademarks and building a brand, and then also competitive advantages being protected with copyright and trade secret. I have the chat open. So again, if you have any questions, please feel free to put it in the chat or flag it for Sam. But with that, let's get started. As I said, the way we're going to do this is first, we're going to do some introductions. Sam's already introduced me a little bit, but as any good attorney, I'm going to talk about myself for a little bit longer. And then we're going to go through some of the ground rules for this conversation, some legal strategies related.
Dan, you cut off a little bit there. Did you want to turn off maybe your video? It might help with the internet connection. Unless it's just on my end. Let's turn off his videos.
My video should be off.
Okay. You might be able to roll now. It might help with the bandwidth, and you can turn it on in maybe a couple minutes or so.
Well, let's see if this helps, because I've now turned off the Wi-Fi on every device I have in my office. As everyone knows, during the COVID pandemic, we've gotten a little more comfortable with being virtual, but every time we try and do something like this, there will be a technical glitch that we have to roll with. So thank you again to everyone's patience. And Sam, let me know if there's any other technical difficulties. But as I was saying, one of the things to keep in mind during this presentation is that I'm going to try and give you as much access to IP knowledge that I have and to my experience with intellectual property, specifically with patents. But again, I'm not your attorney. This is not me giving you legal advice for your particular matter. This is just for educational purposes. Now, this is what I look like. You would see me if my video were able to work. But I am the founder and principal attorney of a boutique law firm focused on startups and small businesses. We try and give as much access as possible to our clients on intellectual property, government contracts, SBA lending, and much more. I've been working with serial entrepreneurs for almost 10 years now, a little bit less in private practice. Before that, I was at the SBA in Washington, D.C., working on behalf of small businesses across the country. And I bring that same passion to my own practice here in New York, and I serve clients throughout the country in these federal matters. The ground rules that I've laid out are that we're going to go through as much content as we can, but please feel free to ask any questions you want related to IP in the chat during the presentation. I will try and answer as many as I can during the presentation, but if I don't get to it, I'll try and get to it at the end. I want you to think about law and business as a high stakes game. Your objective is to try and secure the biggest market share possible, to make the most money, to accomplish the most good if you're in the not-for-profit space or corporate social responsibility space. Your competitors are other businesses, other innovators, other entrepreneurs, other not-for-profits. But in business, you have a series of defensive and offensive maneuvers that you can take to ensure that you meet that goal of either biggest market share, most money, or most good. The rounds are you reacting to each other. So they're not based on time frame. They're more what you've done is going to dictate what the market does. What the market is doing is going to dictate what you're doing. Columns that try and summarize those for you. What's a defensive or some preparation you can take to ensure that you can accomplish your goal? And what are some of the offensive maneuvers that you can take to target some of your competitors to ensure that you get the biggest market share, the most money, or accomplish the most good? The two things I want to highlight on both sides: two defensive or preventative maneuvers you can take are, one, to obtain a patent. You, in doing that, are being proactive in securing your right to your invention and making sure others can't. Same with an exclusive license to IP. If you find that you're focusing on a particular kind of customer, or you're trying to get into a particular market and someone has some of the IP that you would try and develop on your own, you can ensure that you get the market share that you want and preempt your competitors by getting an exclusive license. On the opposite side, if you see that a competitor is trying to do those defensive maneuvers, you can oppose their IP registrations, you can oppose their patent, you can oppose their trademark, you can try and reverse engineer some of their competitive advantage if it happens to be a trade secret. Again, I want you to think of business as a high stakes game. And these legal maneuvers can be both defensive and offensive. And especially when it comes to what gives you a competitive advantage over the competition. If that's a patent, a copyright, a trademark, or a trade secret, you should be thinking about these different moves that you can take in this overarching game, ensuring that you can get the most money, the best market share, and accomplish the most good. I'm going to start off by giving just a broad overview of all intellectual property, not just patents, because every business has IP. Not every business needs each individual kind of IP. And so it's important for every entrepreneur, every innovator, every small business owner, every large business owner to remember there are different kinds of intellectual property and how they can relate to each other as you build your overall IP portfolio. Here are the 4 types of intellectual property. You have, and just keep in mind, there are some additional kinds of IP rights. These are the 4 that encompass most of the IP rights that a small business or a startup will have. And they're patent, trademark, copyright, and trade secret. I'm sure that every single one of you has heard at least one of these, if not all of these. And they cover a different piece of your business depending on what you do. A patent Could be a machine or a process that you've developed that you decide is really valuable and you want to ensure that you have at least 20 years of monopoly over it. So you file for a patent. Your trademark, briefly, is your brand, your reputation, whether that's the name of your business, your logo, your slogan, your sound, or the color of your product. Each of those denote for a customer that that product or that service is coming from you, that has a certain quality, has a certain origin, and it has a certain feeling to it that the customer wants. Copyright is protecting any expression of an idea in a tangible medium, which is a fancy way of saying you've put your ideas into a tangible form. You've written a book, you've recorded a performance, you've constructed a building that has particular architecture that's unique. You've coded an app. You have developed various things that you want to have a monopoly over and you don't want people to copy or create derivatives. You inherently have copyright, but you want to register for that to get some extra protections. And the last one's trade secret, which is the catch-all for all of these, where you have some information or something that gives you economic value and competitive advantage over the others in the market. And if you take reasonable efforts to maintain its secrecy, you can actually prosecute if someone tries to steal your idea. Here are some examples of each of these categories. For a patent, it's very easy to think of some examples of what would be covered by a patent. Most of us have a smartphone in our pocket or on our desk right now. Everything in that iPhone or in that Android device is likely patented or was patented. Semiconductors, the electronic form inside, the motherboard of a computer, the method for making a bunch of the different things in that iPhone, methods for making things as simple as flavored chips. Those are patents. Trademarks, Ignite UNY. That's the name of Ignite U, so they can prevent others from using that name if they got a trademark. The logo, think of McDonald's, the big golden M, the golden arches. Slogans, Taste the Rainbow, Skittles, Just Do It, Nike. Other things like colors and sounds, when you see the color or you hear the sound, you think of a brand, you think of a company. If you see a Tiffany blue item, you immediately think Tiffany and Company. If you see pink insulation in a home, you think Owens Corning. If you hear the particular chime of NBC, you know it's an NBC show, even if you don't see their logo, which is a peacock. Copyright, again, books, movies, paintings, choreography, architecture, applications on your mobile phone, certain fashion designs, and this presentation all inherently have copyright to prevent others from copying your work. Trade secret is often the most fun because it involves a lot of recipes. It's a lot of food. KFC's fried chicken, Coca-Cola, Thomas's English muffins. Each of those are a recipe that the company has maintained a secret over and has not disclosed to the public because that's their competitive advantage. But you also find it in chemicals, where certain paints have a certain chemical composition to ensure that they don't chip. You can also find that with coding and algorithms. Google's search engine is actually a trade secret. The US News rankings for colleges, while they give out the criteria, they don't tell you how they arrive at their results. But for each business, you have a trade secret, whether you're on the scale of a KFC, Coca-Cola, or Google, or if you're just a dry cleaner on the corner. You have a customer list, you have your vendors, you have your suppliers, you have how you make sure that you get an extra level of profit. Those things can be trade secrets, and if you take reasonable precautions to keep them secret, you can prevent others from stealing that idea. I'm going to stop really briefly to see if there are any questions on those 4 different types of IP before we jump into patents.
Dan, I don't see anything in the chat just yet, but our audience, please don't Don't be shy. We're here to answer any of your questions.
I'll see, Sam. I was going to give them 30 seconds and I was just going to jump in.
Oh, okay. No, you're good. That's fine. That's fine.
Sorry, I should have mentioned that I was going to count that 30 seconds really quickly. So let's move on to the subject at hand, which is protecting your invention, when and how to seek. What was that?
We do have a question.
Oh, go for it.
Ed said, shouldn't KFC want to patent its recipe?
It's a great, and I'm going to see if I can go back in my slides. So when you're looking at the different kinds of IP, they do relate to each other. And Ed, you hit on something great for everyone to know, which is patents and trade secrets really cover a lot of the same area. KFC may have decided to try and patent their recipe for some sort of composition of matter. But a patent only lasts 20 years. After the 20 years, it becomes public domain, and that's part of the exchange of a patent. I, as an inventor, create the next best thing, and the government will give me a monopoly. It will tell everyone else they cannot make it so I can make the most money and get a return. But in exchange, I have to tell the public what it is. So if you have a competitive advantage or some value that's going to last far greater than 20 years, you may want to go with trade secret instead. And that's why you see a lot of recipes going into trade secret, regardless of whether they're patent eligible or not. Coca-Cola was, I think, first created in 1887. And they're one of the most profitable companies in the world, based solely on a trade secret. That myth is there's only 3 people that know just a portion of the recipe. No one person knows it. But because they went with the trade secret, they got to monopolize that recipe far more than 20 years. They're well over 100. And that's why KFC and other restaurants and food chains often choose to go with trade secret rather than even attempt to try and patent. I hope that answers your question. Sam, before I move on, are there any more?
Nope, just a thank you from Ed.
I'm going to start really basic. I'm sorry if this is duplicative for anyone, if anyone already knows what these things are, but I want to ensure that we're all on the same level playing field before we really jump into some of the nitty-gritty strategic decisions and monetization things that you need to consider as a patent owner. What is a patent? A patent is a temporary monopoly over an invention granted by the federal government in exchange for the disclosure of the invention to the public. The reason I highlight this sentence is it packs in a great deal of information about what you need to know about a patent. It's a temporary monopoly. For 20 years, up to 20 years, you have a monopoly over your invention, meaning that you can prevent anyone and everyone from selling, making, importing, exporting, and licensing your product. You also might even be able to prevent them that is more used rather than made. That right is granted by the federal government. It's granted by the USPTO, the United States Patent and Trademark Office. So it's not state by state. It covers the entire United States and its territories. And it also applies to countries that we are in treaties with on the national level. The exchange is the really vital part that actually goes back to what Ed had asked earlier. You are disclosing the invention to the public, to the federal government, in exchange for that monopoly. So if you don't disclose the invention fully, you can lose out on your monopoly. It can actually be an invalid patent and get attacked in court. That exchange is where you get this public policy of patents. Why would we give a patent for a vaccine? in order for the pharmaceutical company to get a return on its investment, to ensure that that company is making enough money to pump back into R&D and back into the company. There are three kinds of patents. We're only going to talk about utility patents for the rest of the presentation, but it's important to know that there's three different types, because when someone's talking about patents, they might actually be talking about another kind. Utility patents are how an invention works or how it's used. And that's normally what people think of when they think of patents. Term is up to 20 years. Your patent might be a little less, might be very quick if you have a really evolving industry. But generally, those utility patents cover what we think is patentable. COVID-19 vaccines, Apple iPhone hardware, the way potato chips are flavored, certain machines to do different things in the workshop. Each of those would be a utility patent. A design patent, on the other hand, protects how an invention looks, the ornamental aspects of the invention. The most famous design patent is the Coca-Cola bottle. So if you think of a glass Coca-Cola bottle, you know that one, that's synonymous with Coca-Cola. But two, there's no other company that has that glass bottle shape. And that's because Coca-Cola has a design patent on that Coca-Cola bottle, or at least they did for the first 15 years. Same thing happened when Apple first developed the iPhone. The interface you see when you open your iPhone and you see all of the app icons, that is partly a design patent that Apple secured when they were developing the iPhone. It has no function. It is just merely how it looks. The last kind of patent is a plant patent. Plant patents, by its name, protect distinct and new varieties of plants. These plant patents can be up to 20 years. And you may think it's not as lucrative as a utility patent or a design patent, but with the rise of cannabis industries across the country, different varieties of cannabis are actually being patented. And that's preventing people from using or selling those varieties of plants. Same thing can happen with optimized fruits and vegetables. One example is avocados. There's some patented avocado varieties that are commercially valuable. Like I said, we're going to just try and cover as much as we can on utility patents. And when you think of a utility patent, the patentable subject matter is generally a process, a machine, a manufacturer, or a composition of matter. Process is inherently a series of actions to produce a given result. Could be something to manufacture a good. So it could be making the method of making flavored potato chips. It could also be a business method. For instance, Amazon has a patent for the one-click purchase online on the internet. Machine is a concrete thing consisting of parts or devices or a combination thereof, meaning a machine, whether mechanical, electrical, is patentable. A manufacturer is the end result of that. In most cases, it's the end result of a machine working on some sort of source or form. I am a big fan of Legos. So if you think of Legos, Legos are just plastic molded into a brick form. But there is a patent that was there was a patent for Lego bricks. The last one is a composition of matter. And the easiest way to think about this one is chemicals, pharmaceuticals, something that's combining two or more substances into one thing. And Ed, to your point, this is where you would try and get into whether or not a recipe fits into something that can be patented. Pharmaceuticals, however, you often want to get them patented because the industry develops quite quickly, and you have to make a series of disclosures to the FDA to try and get FDA approval. What is not patentable is not an easy question to answer. There's a lot of litigation around what is not patent eligible subject matter. An invention like a process, a machine, a manufacturer, or a composition of matter, is generally patent eligible. But the things that are not patent eligible are natural phenomena, laws of nature, and abstract ideas. And I have some examples of those so we can try and put some examples to what those words mean. When you think of natural phenomenon, you think of what occurs in nature. If you went to the Amazon and discovered a flower that cured cancer, you can't patent that flower. You could patent the process for extracting the chemical that cures cancer from that plant, but you couldn't even patent the specific chemical because it occurs in nature. Laws of nature are how things relate in nature. And this comes up a lot when you're dealing with medical patents. If I say I'm claiming the correlation between a medication and a precipitate that arises in the bloodstream that I can measure, that's not going to fly because that's natural. I haven't done any inventive concept. Last one's abstract ideas. I can't patent a mathematical formula. I can't patent E equals MC squared. I could not patent an algorithm. I could not patent the economic principles of a free market society. And I can't patent the thought process of someone to arrive at a certain result. The courts have created these judicial exceptions because they are the foundation of innovation in most cases. And so to be patentable, your invention has to be more than these things. It has to include an inventive concept beyond these things. So if you find that flower in the Amazon that cures cancer, you can't patent the flower, you can't patent the chemical, but you can patent the method of extracting the chemical or even a distilled version of that chemical. To be patented in any case, it has to be useful, novel, and non-obvious. What that means is there has to be some utility to the invention. There has to be the ability for it to be patented, and all that means is it's new. So there's not an invention already out there. There's not public disclosures or prior art that shows that people have already thought of this thing. And last, it has to be non-obvious. If I'm skilled in the art, if I'm skilled in car parts, I may have thought already to create what you're trying to patent. And that means it is just obvious. And if it's obvious, it's not patentable. Because if you think of that exchange we talked about earlier, why would the government give 20 years of monopoly, which is valuable and very expensive to the economy, in exchange for something that would be otherwise obvious? To determine whether or not something is novel or not obvious, you have to look at the prior art. And prior art is generally printed publications, so articles, periodicals, presentations, anything on the internet. You have to look to issued patents, patent applications, and various public disclosures like speeches or public test to see if these things existed before you filed your application or before you made a public disclosure of your own. I generally want to go over how to get a patent because it's going to educate us as we go into some of the other considerations for getting a patent. This is a very brief description of how to get a patent. Obviously, there is a lot that goes into this. I highly suggest that if you're thinking about getting a patent, you consult with a professional because if you don't do it right, you could lose a lot of value, whether it's in the examination or in how you're licensing and monetizing the patent at the end. So always start off with
Dan, Dan, are you still there?
I am. Can you not hear me?
You might have cut off for a second, but we do have a question. We have a couple questions.
Awesome. Let's go back to the questions. I'll come back to the steps to patent after the questions.
Let's see here. From Grace, are DNA sequences patentable? Example, samples from a 23andMe test.
It's a great question. You have to, so Grace, when it comes to DNA, DNA itself is naturally occurring. So those sequences are not patent eligible. And I would direct you to a case called Myriad, where the court dealt with cDNA, which is a copy of DNA. The DNA sequence itself is not patentable, but if you replicate the DNA and you do something to the DNA that doesn't occur in nature, then you may get into a patentable subject area. If you're dealing with 23andMe and some of these companies that take DNA samples to run tests, the DNA sequence that you're giving them is not patent eligible. The process of how they're testing your DNA may be patentable. I hope that answers your question.
We have
Yeah. No, go ahead. I was going to ask what the next question was.
Yeah, a follow-up question from Grace. What defines the differences between an algorithm and a programming script?
Well, in either case, you're likely not looking at a patent, because if you do a programming script, you're likely looking at a copyright, because it's it's putting an idea to a tangible medium, whereas your programming script likely implements a process. That process may be novel, maybe non-obvious, but likely isn't. The difference between an algorithm and that coding structure is really case by case, and it depends on what you're trying to patent. If you can distill your invention to just a mathematical equation, you're likely not looking at patent eligible subject matter. That's not to say that you shouldn't look at other IP. You should look at copyright. You should look at trade secret. Again, Google is just an algorithm on how to search internet web pages. While it might not be patentable, you can certainly make a lot of money from it as a trade secret.
We have a question from Tierra, one of our alumni. How you doing, Tierra? And the question is, how do you know if the professional you're working with has your best interest in mind?
Well, if you're talking about in the IP context, it depends obviously on what you're doing, but generally keeping communication open and making sure that everything's explained in a way that you can understand it is one way to ensure that they're acting in your best interest. When it comes to a patent, when you file and the patent examiner is reviewing it, there's a lot of negotiation that happens. You may have to withdraw some of the claims you're trying to make in exchange for the government to grant you that patent that you want. And you need to ensure that your attorney or the person in your company acting on your behalf has an understanding of what your interest is, to ensure that you don't give up too much or that you leave things on the table.
Tara also provided an example. For example, patent companies who are not attorneys but work with patent attorneys. If that was more related to her question. Sorry, I didn't see that at first. But I think you did answer that regardless. Alrighty. That's the questions I see here for now, Dan.
Okay.
Continue to keep my eye on the chat. Thank you, everyone, for all the questions. Keep them coming.
So, as I was saying, the steps to patent are generally these 6. It is not an exclusive list. But when you're thinking about getting a patent, the first stages you should be in are, is this a patentable subject matter? Is it a machine, a process, a manufacturer, a composition of matter? Is there prior art that's already out there that shows that this is not novel and non-obvious? So start searching for other patent applications, other scientific research. Look for people who post things on YouTube, frankly, and see if other people already have your invention. Another easy way to do that is see if anyone's selling it already. Then when you've done all of these things and you've possibly consulted with a professional who has your best interests at heart, you can file an application. There are 2 kinds of applications. There's a provisional and a non-provisional. The main difference is that a provisional, which I'll go into in a little bit, is a preliminary application. At the end of the 12 months, it doesn't give you a right to that claimed invention. What it does give you is 12 extra months of developing your idea, possibly preempting the competition, and just buys you more time while saving your spot in line. A non-provisional, however, is your actual application. It's where you disclose your invention in exchange for a temporary monopoly and where you claim your specific invention. 5 and 6 deal with that period I was talking about where there might be some negotiation and navigating around what the government wants. The USPTO is going to examine your application, and over several months, they're going to give you some responses. They're going to give you some objections, possibly some rejections, where they're going to tell you what they're not going to agree to, what already exists, what they think is not novel, and what is obvious. And your attorney or yourself, you have to make sure that you're negotiating and trying to get the best results you can by disclaiming some things, withdrawing some applications, or possibly just taking a new direction. But at the end of it, you hopefully have a patent. You put patent pending or your patent number to mark your product. And then you worry about some of the strategic decisions you have to make thereafter. Here are 4 common pitfalls that I've seen a lot of inventors, startups, and small businesses fall into when they're considering a patent or they have something that really could be patented very easily. The first one is public disclosures. If you, as the inventor, publicly disclose your invention, you have a 1-year grace period from that disclosure to file your patent application. If you don't file within that 1 year, your invention becomes part of the public domain. It actually becomes prior art against you, and it becomes part of what they call the public consciousness in some circles. These public disclosures can be presentations, they could be articles, they could be conversations you've had with individuals absent an NDA, a non-disclosure agreement. It could be you using your invention in public in excess of experimentation, or just generally making it otherwise available to the public. As I alluded to earlier, and I'll mention again later, public disclosures can be used strategically to give you more time and preempt some of your competition. But generally be very weary of public disclosures because it can tank your patent eligibility very quickly if you're not monitoring it. Same thing for offers for sale. If you make an offer of your claimed invention to someone, whether it's secret or in public, you have 1 year from that offer to file a patent application. It's the same grace period. If you don't, once again, your invention becomes part of the public domain, and you are no longer eligible for a patent in most cases. The third one is failure to maintain. This is a very easy step that patent holders often forget about. Every 3.5, 7.5, and 11.5 years, you have to pay maintenance fees to the PTO, basically saying, I still value this patent, I still value this monopoly, and I want to keep it. It's 0.5s. 3.5, 7.5, 11.5, because there's a 6-month extension you can ask for. But after that full 12 years, after the full 4 years, 8 years, 12 years, you may actually have your patent deemed expired by the PTO if you fail to pay those fees. There's a process to revive a patent if that happens, but it's costly. And I suggest that if you get a patent, make sure that you are paying attention to your maintenance fees and avoid any problems with expiration. The last one that's a common pitfall in my view is deficient filings, whether it's purposeful or just negligent. Failing to give certain information to the PTO can be fodder for someone to invalidate your patent in court. If you invent something, say Sam and I go into business together and we invent the world's greatest widget, and It's novel, it's non-obvious, it's useful. There's nothing else like it. I go to the PTO and I file a patent and I don't disclose that Sam was an inventor with me. That can cause serious problems down the road if I get an issued patent. It can cause serious problems if the PTO finds out that he is a joint inventor even before they issue the patent. It could prevent me from getting a patent at all. It could also invalidate my patent after the fact. It could also cause problems for licensing and assignments of the patent if I try and sell it. So again, just make sure that you don't lose track of who even contributes a little piece of the invention. Here are 4 strategic decisions that you should consider as a patent holder when you're going through the life of a patent. First is when to file, and this seems like a very obvious question to most. Do you want to file a non-provisional application now, or do you want to wait? Do you want to try and prevent the competition from anticipating you and filing their own? And how do you do that? Do you file a non-provisional immediately? If your claimed invention's not fully developed, you might want to just make a public disclosure or file a provisional application. That second piece, filing a provisional application, is to do 2 things usually. It's either to anticipate the competition by getting an earlier filing date, or to buy yourself more time while you finalize the invention. A provisional application is different from a non-provisional in that you don't have to make claims. You still have to disclose your invention to the government as best you can, but you do not have to make the specific claims of what your invention is. And that's actually a huge benefit for provisional because it buys you 1 year to finalize those claims and ensure that you're not going to get tripped up down the road. Filing a continuation or continuation in part, I'm not going to go deeply into these because it's very complicated, but it should be something that you're knowledgeable on. And a continuation or continuation in part are additional patent applications that you can file that claim back to the previous patent application you filed. So to put it in a more tangible way, if I file a non-provisional application today and I develop an improvement on what I just filed for, or the PTO rejects part of my claim, before they issue my patent, I can file a continuation or a continuation in part where I try to claim those things and still get the benefit of my earliest filing date, because that filing date dictates whether or not someone's infringing my rights. These things also factor a lot into building a patent portfolio or a family of patents, which investors really like. It's also great for developing a monopoly that's longer than your 20 years, that lasts a considerable amount of time. It's not going to get you to have more than 20 years for any particular invention, but it does give you more dominance over the market in some cases. It also gives you the chance to save anything that got rejected by the USPTO during your application process. The last one is disclosing on purpose. If you disclose on purpose, you can prevent your competition from anticipating your application, from becoming prior art against you. This is something I would highly recommend doing with a professional, because if you aren't clear on what the disclosure is, on what the timeline is, you could very easily fall into that pitfall where you make a public disclosure and don't file within the 1 year and lose out on a patent entirely, even though you were trying to get this benefit of anticipating your competition. The ways to monetize patents once you have one are fairly straightforward. You can make it, sell it, license it, or enforce it. Make it, it's obvious. If you have a patent, you now get to make, sell, use, import, or export your invention as much as you can during the 20 years of your patent. You can also sell your patent or assign it to someone who wants to buy it from you. And that's because patents are a tangible asset of your business. They're the same as a restaurant having a refrigerator or grill. It's a tangible asset that you can sell if you get into a bind and need some capital, or you're trying to execute a merger and acquisition. A license can be in various forms and give you the opportunity to monetize your patent without making it. So if you are trying to think of one, think of BlackBerry. BlackBerry is not really ubiquitous in cell phones anymore. However, they own a lot of patents that are the crux of the modern iPhone and the modern Android technology. So they have a lot of licenses out to these companies so they can make their own iPhone, make their own cell phone. These licenses, when you're doing them, there are certain attributes to them that you want to think about because they dictate how much control you have. Obviously, a license, you're trying to get royalties or some other compensation in exchange for letting someone else make your invention. You want to think about whether it's exclusive or non-exclusive. Is this person the only other person that can make it? Or is the license something, one of many that I can make? Is it temporary or is it perpetual, meaning that it's permanent forever? Is it revocable? Can I take it back? Is it irrevocable? Is it a full license or a partial license? Did I give them the full invention or only a piece of it? The last way to monetize is a touchy subject because some people look at non-practicing entities in a disparaging way. And that's because this last option is if you're a patent holder, you just sue people and seek royalties or seek damages for their infringement. And that's where patent trolls come in, or non-practicing entities. However, there are some positive non-practicing entities that you also should think about. Research institutions, universities often develop technology that they're not prepared to make on their own. So they will sometimes turn into a non-practicing entity where they are just trying to seek royalties, and they often are suing people for making their product, making their invention. That is a broad overview of patents. Obviously, there's a lot more content that I don't have time to go into, but I'm happy to answer any questions you have on patents or the 4 IP forms that we talked about at the beginning of this. And so now the floor is open for any questions you have.
I have a couple questions, Dan.
Sure, go for it.
Through text to me. Can you explain more detail what a provisional patent is? And is there any easier steps before a provisional patent?
So a provisional patent is most easily explained when comparing it to a non-provisional. So to patent something, you have these 2 roads you can take. You can either file a provisional application or a non-provisional. A non-provisional is what's going to actually give you the rights that you're trying to seek over this invention. A provisional is just to save your spot in line and only lasts for a year. A provisional application, you disclose the invention, you go through a lot of the application that you would use for your non-provisional. So when you file a provisional application, you're going to include a disclosure of your invention, possibly some drawings, but you're not going to include claims. You're not going to try and claim your invention because the PTO doesn't examine a provisional. A provisional is truly just to save your spot in line and to save the earliest filing date you can. You can take a lot of the content you create for your provisional and use it for your non-provisional, because your non-provisional within that year from your provisional is supposed to closely align with your provisional disclosure. And so your non-provisional could have very similar invention disclosures, specifications, drawings if you included any, but then has to have claims. It has to actually claim the invention, and then the PTO is going to review and see if you are actually eligible and if you have the ability to get that right of monopoly. I hope that answers your question. What's next, Sam?
I'm here. I'm trying to. We have a question from, I hope I pronounced your name right, Joanne. Is there a database of provisional patents that can be searched?
Is there a database of provisional applications that can be searched?
Provisional patents.
Sorry. Okay. So provisional patents are not published. So there's no way for you to search for provisional applications. If they come up, if an application is existing before your actual application, it could be prior art. But generally, provisional applications are not publicly disclosed.
Okay, I'm just catching up here, Dan. I got another question. What are the logical business steps for a startup in tech for the IP process? Like step 1, step 2, like what are the logical business steps for a startup to consider, maybe go through when pursuing maybe IP?
If startup, very beginning, you're thinking of the solution that you're creating to a problem that the market has. How do you protect it? And that goes to those 4 different kinds of IP that I talked about. Because I often say not every business needs a patent. You might be better suited for copyright, especially if you're coding. If you are a restaurant, you're likely looking at trade secret rather than a patent. In every case, except very few, you're going to need a trademark. You're going to need a logo. You're going to need a company name that's synonymous with you. So IP should be a very early consideration for startups. When you get into the nitty gritty of whether or not you should go into a patent, ask what prevents someone from just copying what you're doing? And that's a really early question you should be asking as a startup. I hope that answers your question. Sam, can you still hear me?
Yes, I can hear you.
Okay, because I'm going to turn my video back on so people can hear me. People can see me while they hear me.
Can you hear me?
I can.
Perfect.
I'm gonna stop sharing my screen, by the way, because maybe that'll help.
If anyone has any other last questions, feel free to put them in the chat. In the meantime, we do have a couple minutes here. I wanted to thank Dan again for being here today. This is just part 1 of 3, so we get Dan for 2 more weeks. The next part 2 webinar will be next Wednesday, a week from today. Today's Wednesday, right? At the exact time at 1 p.m. I believe it's the 26th. Yep, May 26th. At the same time, you guys will receive a follow-up email thanking you for attending, and to fill out a quick feedback form for us to continue improving the experience for you guys, and asking you any other topics that you want to discuss, whether that's related to Dan's series or future webinars that we do with other SMEs. And within that email, there should be a link for registration for part 2. In addition, if you're following us on social media, or if you're on our listserv, you'll see some content and promotions being pushed for part 2 to register if you haven't done so already. But these are completely free to you guys, so please take advantage, and we hope to see you at part 2. We had some questions whether or not this will be shared. The recording will be shared. We will be putting that up by the end of the week. So if you do follow us on social media, It could be even put up by tomorrow, but let's say by the end of the week to be safe. If you guys follow us on social media, we do re-promote this particular recording. And in addition, we do have some alumni in here. In Tierra, I know one of them is Tierra. She's all the way from Seattle. We are accepting applications for our 2021 Summer Accelerator program. So that is an opportunity for you to work with our team directly for 8 weeks to continue having access to our subject matter experts such as Dan and others, and for us to help you grow your business. You can learn more on our social media. We've been pushing that heavily. Or if you go to igniteuny.com, you can go under Summer Accelerator and where those applications are still live. We are closing applications June 1st for our Summer Accelerator, so don't miss out, and please submit an application. It doesn't hurt to apply. Other than that, I'm looking through the chat here, Dan, and I'm looking at the Q&A section. I don't see anything else, but thank you so much for being here today with us. And we will see you next Wednesday. Did I forget anything? Anything else you wanted to add?
No, the only thing not just ones that have a patentable technology. So if you or anyone you know are thinking about starting a company, come to the presentation, come with questions, because we're going to talk about why your name, your logo, how you look, how you sound is really important to your business, and how to prevent others from copying you. But thank you again, Sam, for the invitation, and to Ignite You for hosting. And if anyone wants to reach out to me, just ask Sam for my email and find me on LinkedIn if you want. But I look forward to seeing everyone in a week for trademarks.
Okay, we'll see you next week. And you guys, everyone, Dan has been tagged in all of our social media on LinkedIn and Twitter too, at least. So you can always connect with them on there. Thank you again, Dan. You guys all have a good rest of your week. And let us know if you have any questions. Feel free to reach out. See you guys.